Hi, my name is Joyti Bala. The case study today I and my group members going to present is Bank of India versus Mr. Gobindram and others. The Bank of India initiated a suit against Mr. Gobindram and family, who had acted as guarantors of a line credit of 230 million yen that Bank of India's Osaka branch had provided Sadhwani Japan Limited. The Govindrams were residents of Hong Kong. SGL had drawn bills of exchange that were supposed to have been paid by SGL's corporations in Nigeria and Sri Lanka. That those corporations were run by other brother of Mr. Gobindram. But these bills have been dishonored, and bank sought payment from Mr. Kishan Chand, who owned 60% of SGL. But he said bank should pursue its guarantors, who were Mr. Gobindram and family. But bank did not care about that because it has already agreed the family as guarantors. The bank finished by pursuing them in front of the Hong Kong court. So now I would like to call Ejaz to continue with the presentation.
Hi. Since the parties involved in this contract reside in different countries, so the complication is which law should govern the contract. Now, to determine the contract, according to Dicey and Morris conflict of laws, rule number 180 states the following. The term proper law of contract means the system of law by which the parties intend the contract to be governed, or where the intention is neither expressed nor to be inferred from the circumstances. The system of law with which the transaction has the closest and most real connection should be in effect. Now there are sub-rules to this law number 180. The rule number 1 is we have to see if the defendants explicitly mention which law should govern the contract. If that doesn't happen, then we have to go to the stage number 2, where we have to check if any intention or reference was made from which an inference can be drawn about which law should govern the contract. Now if that doesn't happen, then we have to go to the final stage. Now the third stage is the court has to find the closest and real connection, the most real connection to the contract. Now let's see what happens in our case. In our case, the onus of establishing the law of the contract is on the defendants. Now the defendants did not explicitly mention which law should govern the contract. They failed on the first stage. Now we have to go to the second stage. Now the second stage is the defendants failed on the second stage as well because they did not mention anything from which the law of the contract can be inferred. Now under the rule number 180, the sub-rule 3 states, when the intentions of the parties to the contract with regard to the law governing is not expressed and cannot be inferred from the circumstances, the contract is governed by the system of law with which the transaction has its closest and the most real connection. Now, the court actually look into some factors to determine the law. The court looks into the place where the contract was made, place of performance of the contract, place of the residing place of the business parties, or the court can look into nature or subject matter of the contract. Now my friend Prasanth will explain how to determine the law of the contract for this situation.
Hi, now I am going to explain the determinants of law which should be considered. There are 3 laws under this case. The first law is Indian law, the second one Hong Kong law, and the third one is Japanese law. We will look at the reason for all of them and then establish on the basis of those reasons that which law should be considered. Originally, the contract that has stated in Indian currency, which could be considered as a connection to India, but it was replaced by an later on. This indicates that Japanese law should be a common choice. The SGL company was a part of Indian family business, but conquering options were in Japan. The Bank of India was in Japan too. Both factors ruled Indian law as a preferential choice. Now the second one. Now considering the Hong Kong law as an option, the only link that can be drawn towards Hong Kong law is the possibility that Gobindram might pay in Hong Kong. Regardless of the place of the payment, the place of the performance is still held in Japan. Now my friend Nulu is going to explain the remaining part.
Since we have considered a few factors to rule out India and Hong Kong, now we will look at the factors to consider Japan. 2 guarantors lived in Japan out of 4. Kishan Chan, who is active participant, lived in Japan. Also on top of that, he took decisions on behalf of the co-guarantors. The whole negotiation took place in Japan, making it strongest place of performance. Principal sum which was guaranteed was in Japanese yen. On top of that, the contract itself bears 100 yen stamp. All the factors together indicate the inescapable connection of Japan. Hence, it is established in the light of all the evidences that Japanese law should come in the contract. Thank you.